Imagine the high-stakes drama unfolding in the world of auto racing, where billionaires and legal titans clash over control of a multi-billion-dollar industry. Could a single mediation session change everything? That's the electrifying scenario playing out as NASCAR braces for potential resolution in its heated antitrust battle with 23XI Racing and Front Row Motorsports. But here's where it gets controversial. When the very judge slated to oversee a potential trial steps in as mediator, blurring lines that could sway the outcome. Stick around to dive into the details, because this isn't just about cars and tracks. It's a lesson in how power and law intertwine in sports. Lawyers and representatives from NASCAR, 23XI Racing, and Front Row Motorsports are gearing up for a pivotal meeting tomorrow morning at the U.S. District Court in Charlotte, North Carolina. Unlike past court sessions where Judge Kenneth D. Bell, a 67-year-old ex-federal prosecutor, acted strictly as the judge, he'll now take on the role of mediator to facilitate talks aimed at settling their prominent antitrust lawsuit without needing a full-blown trial set for December 1st. Bell's primary mission? To uncover mutually agreeable terms that satisfy both parties, allowing them to withdraw their claims and sidestep the jury process entirely. Now, for those new to legal proceedings, mediation is a common low-stakes approach where disputing sides discuss their issues openly with a neutral third party guiding them toward a compromise. It's designed to be less adversarial than a courtroom showdown, emphasizing collaboration over confrontation. But hold on, this is the part most people miss. It's exceptionally rare for the judge presiding over a case to double as the mediator, adding an extra layer of intrigue and potential bias to the proceedings. And this is where things get really interesting. Mediation sessions are kept strictly confidential, creating a more relaxed atmosphere compared to the formality of a trial. Participants can speak freely, knowing their words won't be used against them later in court. Yet, what sets Tuesday's gathering apart is that the same individual, Bell, will hear the arguments from key players in motorsports, and then later judge the evidence if the case proceeds to trial. That trial would involve a jury deciding whether entities like NASCAR, its CEO Jim France, Front Row, 23XI, and 23XI co-owner Curtis Polk, or any mix of them, broke federal antitrust laws, which are rules meant to prevent unfair business practices that stifle competition. Think of antitrust law as the referee ensuring no one monopolizes the game, promoting fair play in markets, important for beginners to grasp, as it's the backbone of many corporate disputes. But Bell won't be a passive observer during any trial. As the judge, he'll make crucial calls on what evidence can be presented, how witnesses give testimony, and other pivotal decisions that could heavily influence the verdict, potentially even overruling the jury if legal grounds allow. To illustrate, consider a similar high-profile sports antitrust clash from last year involving the NFL's Sunday Ticket. A jury ruled that the NFL and its 32 teams violated antitrust laws by bundling broadcast rights through the Sunday Ticket, which supposedly made it more expensive for fans outside a team's city to watch games, affecting subscribers like homes, eateries, and pubs. The potential payout could have reached a staggering $14.1 billion. However, the presiding judge, Philip S. Gutierrez, overturned the jury's decision via a judgment as a matter of law, arguing that the jurors misunderstood the complexities of antitrust principles and that no sensible jury could have concluded there was widespread harm or financial losses. This example underscores why, in the NASCAR matter, it's vital for all sides to ensure Bell grasps their viewpoints completely, because a judge's rulings can be the game changer. Bell took the initiative to appoint himself as mediator earlier this month, following NASCAR's request for a judicial mediator, not specifying Bell, and counterproposals from 23XI and Front Row to retain Jeffrey A. Mishkin, a seasoned sports lawyer and former NBA official who'd been mediating for months without success. Mishkin will join Tuesday's session and contribute as Bell permits. The lineup promises star power: lead counsel Christopher S. Yates for NASCAR and Jeffrey Kessler for 23XI and Front Row, alongside clients like Michael Jordan, Denny Hamlin, and Polk from 23XI, plus Front Row's owner Bob Jenkins. Expect NASCAR CEO France and other executives to be there too. Since mediation thrives on dialogue, we might witness direct exchanges between heavyweights like Jordan and France, with Bell probing for reactions through hypothetical scenarios. The aim: to navigate the conflict via honest, off-the-record chats that reveal underlying interests. Still, the chances of wrapping this up immediately are slim. The factions are firmly dug in. 23XI and Front Row argue that NASCAR's charter system, which other teams have signed and some owners credit for raising team values, grants the organization excessive authority and revenue slices. For clarity, charters are long-term agreements between teams and NASCAR, securing race spots but restricting participation in rival series and waiving future legal rights. NASCAR counters that these charters boost team worth and income streams, and paints 23XI and Front Row's demands for perpetual charters, like owning stakes in NBA or NFL teams, as incompatible with racing's open entry model. Unlike those leagues, where new franchises aren't easily born, NASCAR's system allows newcomers like 23XI, formed just 5 years ago under Jordan's leadership, to emerge. Even if Tuesday doesn't seal the deal, it could sow seeds for an eventual agreement before December 1st. Both sides have strong reasons to dodge a trial. Grueling cross-examinations of icons like Jordan and France, plus the risk of defeat, followed by drawn-out appeals that could disrupt the entire sport. After all, entrusting the fate of an industry to everyday jurors is a gamble, perhaps a compelling nudge toward compromise. Here's the controversial twist that might divide opinions. Is it right for a judge to mediate their own case, risking perceptions of impartiality? Some argue it accelerates resolution and leverages insider knowledge, while others see it as a slippery slope toward bias. What do you think? Does this setup unfairly tip the scales, or is it a smart way to cut through red tape? Share your thoughts in the comments. Does this remind you of other high-stakes legal dramas in sports? And how might it impact NASCAR's future? Agree or disagree? Let's discuss.